My name is Gabriel Motzkin. I'm the director of the Van Leer Jerusalem Institute, and it's my extreme pleasure and honor to host this important evening in our life, and I'll explain consequently who Sir Zelman was for us. But before I do, I would like to present to you the ambassador of Australia, who is with us tonight, Ms. Andrea Faulkner, who brings the greetings of a country in whose history Sir Zelman played a prominent role. And she has been, for most of her career, with the Department of Foreign Affairs and Trade, where she has filled central functions in both the Africa branch and the Middle East branch and the executive branch and on. And she has served abroad in Hanoi and Paris and previously also in Tel Aviv. So without further ado, please, Your Excellency.
Thank you very much, Professor Motzkin. Now, am I at the right level to be heard? Yes? Okay, good. Thank you very much for the privilege to be here tonight at this august institute, to be in the presence of so many distinguished guests, to be about to hear Justice Procaccia on such a profound topic, and to represent Australia at this event memorialising such a great Australian, Sir Zelman Cowen. From what I've read, Sir Zelman had a record of achievement from a very young age, probably from the moment he began to speak or even to think. From 1977, he was known to most Australians as our Governor-General. To this most senior position in our country, he brought, in words he himself adopted from Nehru, a touch of healing that was much needed by our country at that time. He was able to do that because of a lifelong, extraordinary and weighty combination of cerebral and personal qualities, of intellect, of humanity, curiosity and dedication to service. Now, I know that Professor Motzkin is going to speak of Sir Zelman in just a moment. From an Australian point of view, the examples of all of these qualities are manifold. His service in the Royal Australian Navy, his university appointments, his mentoring of important people in Australia's history, his writings, his engagement with the media. I read today that he was very early on television, so demonstrating a real skill with new media at that time. His scholarly excellence, his contribution of ideas. Only today, also, I was seeing quotes from his 1969 lecture series on the erosion of privacy, and it struck me of what an important reminder this was of the centrality of his contribution on and his thoughts in very important debate that is still current today. And these contributions were made in Australia and obviously internationally. So it strikes me as being apt that such a man of ideas should have played such a role in this place of ideas at the Van Leer Jerusalem Institute. And I am proud that Sir Zelman, one of Australia's greatest statesmen, is being memorialised in this way tonight. Thank you very much.
Thank you, Your Excellency. Now, I am pleased to be able to introduce tonight's lecture, and I first wish to say a few words about Sir Zelman Cowen, and then present our distinguished lecturer, Justice Procaccia. I don't know how many of you have read Sir Zelman's memoirs, but I devoted a weekend to this singular pleasure. As an aficionado of memoirs, I can tell you that Sir Zelman's memoirs are as remarkable for what they leave out as what they include. Namely, Sir Zelman rarely permits himself a negative emotion about the people he describes. It is apparent from the memoirs that Sir Zelman combined two traits: astuteness about people, and the ability to make intelligent decisions. He was not self-reflective, so he does not give you a method of how to do this. Rather, time and again, a mini-portrait of a person is followed by a description of a situation and then a resolute decision about how to solve this problem. To hear him tell it, his successes far outnumbered his failures. But why was that? I think it was because Sir Zelman recognized what he could not do and never tried to do it. He had a homing instinct for the kind of solution that he could carry through. He was not afraid of unpleasantness. Most times, his internal serenity was not shaken by the travails of public life. Instead, he confronted some very shaky situations, both as President, Vice-Chancellor, as President of Australian universities, and then as Governor-General, with an unflappable manner. He is almost dismissive of his success in binding the political wounds that troubled the Australian body politic in his years as Governor-General. That is because he had been used to what he regarded as the far more difficult task of kick-starting a university as Vice-Chancellor, what we call President, twice in his working life. He was used to the obstreperousness of his interlocutors, and he never let it disturb his equanimity. Now, this is almost amusing when you know what he's talking about. He has 2 pages about Van Leer in his memoirs, and I think that if you may be so indulgent, I will read you a couple of this. And he says, between 1987 and 1995, I was on the board of the Van Leer Jerusalem Institute, and for several years I served as its chairman and visited frequently. The institute had an interesting history. Its creator was an extraordinary woman, Polly Van Leer, wife of Bernard Van Leer, head of a large multinational packaging company. Based in the Netherlands, the Bernard Van Leer Foundation was dedicated to the welfare of children in different parts of the world. Polly's husband provided her with resources to pursue an idiosyncratic vision. She perceived a spiritual crisis in humanity and sought to benefit mankind and advance the spiritual and human culture in Israel through an institute that would implement her ideas. The rank of her distinguished advisors changed constantly, as did her spiritual ideas. She secured from the government of Israel a splendid site in Jerusalem on which she undertook to provide, alongside the Institute, premises for the Israeli Academy of Science. The exact programs of the Institute still being imprecise, the construction of a handsome building proceeded to completion in the late 1960s. Generous funding for its operation was available. In 1969, Yehuda Elkanah was appointed director. He was 29, this is not true, he was 35, and a scholar of the philosophy of science, and a man of remarkable intellect and energy whose interests ranged widely. His style was reminiscent of Peter Nettle, that's his best friend. He brought together a group of people who devised a range of programs to address problems in Israeli society, to foster good relations between Jews and Arabs, and to promote cultural activities. This did not meet the intentions of Polly Van Leer, whose spiritual aspirations were difficult to interpret and implement, but it did appear to do useful and practical work. I enjoyed my connection with the Institute and the many good people who worked in it, and the many distinguished people I met through my involvement with it. So there you have it. And I think you get the spirit of the man from what I've just read, and his wry and somewhat understated style that he had perhaps developed as in Oriel College, where he went at Oxford. He was then, after being Governor-General of Australia, the provost of Oriel College, and it is as that he joined our board, that you can understand. So you see that he was still somewhat loyal to the institutions that he served. Now I would like to turn to our distinguished lecturer. When I was performing the intellectual exercise of thinking which lecturer would please the spirit of Sir Zelman that I imagined in my mind, the name of Ayala Procaccia immediately came to mind. Now, Ayala has had a distinct, Justice Procaccia, I say Ayala because she's a personal friend, but Justice Procaccia has had a distinguished career in every aspect of the Israeli legal system, from the Ministry of Justice, from legal counsel to the Israel Securities Authority, judge in all the various court levels, magistrate and district, and served 10 years on the Supreme Court of Israel. But However, beyond all this, what I have to say to her, to say about her, is that I remember very much one thing she did for all of us, was that as a district judge, many years ago, she opened the movie theaters on Shabbat. This is one person in Israel did this, who is with us tonight. Now, at this time, that occasioned a lot of demonstrations in Jerusalem. There were uproar. But this decision stands, and it has been now accepted by all Israelis. In other words, both Sir Zelman Cowen and Justice Ayala Procaccia share a common commitment to the autonomy of individuals. And in that spirit, I am pleased to call her to deliver her lecture on Israel as a Jewish and democratic state, freedom of religion and freedom from religion. Justice to Procaccia, please.
Thank you very much, Professor Motzkin. Honorable Ambassador Faulkner, ladies and gentlemen. I'm deeply honored to be here tonight and deliver a lecture in memory of Sir Zelman Cowen. His exceptional professional achievements and impressive public career have been fully described by our previous distinguished speakers, and none less his tremendous contribution to this important institution, for which the Israeli society shall always be deeply grateful. We shall honor and cherish his memory for years to come. I shall now approach the topic of our discussion. How does the Israeli legal constitutional structure confront the inner struggle between an individual's basic constitutional right to freedom of religion as against the basic human right of another to freedom from religion? Have we succeeded in solving this basic civil-religious collision typical to our multicultural society? And if not, what means should be taken to ease the tensions and bridge the gap between religious and non-religious segments of our society? Israel is a constitutional democracy. It is featured by two main characteristics. First, the institutional democracy, meaning the rule of the majority based on free elections and governmental institutions operating under principles of separation of powers. Second, the substantial democracy, meaning a system of basic individual human rights protected by constitutional principles. Though we do not have a full-range written constitution, human rights are protected in Israel by basic statutory laws that maintain constitutional supremacy, by rules of common law, and by judicial review of the Supreme Court over the legislative and governmental actions concerning human rights. These two combined features lie at the core of Israeli democracy. They protect the rule of the majority on the one hand and guarantee rights of individuals and minorities from coercion of the majority on the other hand. But being a democracy does not fully describe Israel's political, social, and legal regime. Aside of being a democratic state, Israel is in essence a Jewish state. The Israeli Declaration of Independence declared Israel as a democracy of the Jewish people, based on the rule of the majority and the protection of human rights. The dual feature of the State of Israel as Jewish and democratic state is emphasized in our basic constitutional laws dealing with the supremacy of certain individual rights. It is reflected in the general scheme of our statutory and judicial norms. The philosophy underlying the Jewish feature of the state is based on the idea that Israel is the land of the Jewish people, where Jews from the diaspora gather and realize their historical national bond with their ancient homeland. The Jewish character of the state combines ancient Jewish heritage with modern values of Zionism. This dual combination of Jewish and democratic elements lies at the core of the Israeli governmental system and value structure. It distinguishes Israel significantly from other constitutional democracies in the Western world. Our political structure, as well as our legislative and judicial system, are marked by this dual character of the state. It has direct bearing on questions relating to freedom of religion and freedom from religion, being the two facets of the basic individual human right of freedom of conscience and belief. There is an intrinsic tension and at times direct contradiction between the democratic and Jewish features of the state. Being a democracy, Israel's constitutional system protects freedom of conscience and belief and the right to personal autonomy of the individual. From these basic rights emanate the freedom of religion and freedom from religion. However, being a Jewish state may reflect upon the weight given to the right of freedom of religion in derogation of the right to freedom from religion. How does this coincide with the constitutional human right of the secular individual to freedom from religion? How is the natural tension and at times the collision between freedom of and from religion to be reconciled, if at all, in view of these dual features marking the Israeli social, political, and legal structure? Is it possible at all to reconcile these basic constitutional human rights to freedom from religion with the Jewish character of the state? Is it possible at all to combine them harmoniously? These deep and complex social cultural dilemmas have occupied the Israeli society since the foundation of the state more than 60 years ago. I shall take a brief look at how Israeli law and courts have dealt with the inherent tension between freedom of and from religion in the dual-featured system of the Jewish and democratic state. First, it is important to note the Jewish element of the state is far from being a monolithic concept. It is a combination of national, Zionistic, and Jewish religious features. The national Zionistic element is reflected, for example, in the idea of the right of return of every Jew to the land of Israel, by the deep and vast Jewish culture and history, by the Hebrew language, national holidays, and Jewish education. However, the unique history of the Jewish people in the diaspora along 2,000 years brought about fusion of Jewish nationalism with Jewish religion to become almost inseparable ingredients of the Jewish entity of the state. Consequently, since the institution of the state in 1948, basic elements of Jewish religion have penetrated deeply into the legal and judicial structure of the state. Religious bodies were given the legal authority to regulate religious life in the country. Restrictions on Jews to work on the Sabbath were imposed, and similarly, public transportation and the operation of theaters and movie houses were prohibited on the Sabbath. Limitations were imposed on the selling of pork meat and the selling of chametz on Passover in public places. Statutory laws imposed Jewish religious law of the Torah on matters relating to marriage and divorce of Jews in Israel. The deep penetration of religious elements into the Israeli legal system was made possible by the political structure of Israeli governments throughout the years, which are coalition governments that include the religious parties, and due to status quo agreement regarding religious matters between the coalition parties dating back to the days of Prime Minister Ben-Gurion. the status quo agreement has effect on the political interrelations up to this day. The National Zionist feature of the Jewish state has not created as a whole a direct clash with basic human rights relating to freedom from religion. However, where the Jewish character of the state transforms into religious normative rules that maintain coercive power upon the secular public and impose religious directives binding upon one's private life, a forceful collision arises. That requires a balanced solution essential to a diverse multicultural society. Instances of social clash between secular freedom of conscience and belief and the right to exercise religious practices often arise. The constitutional values of our system are called to formulate inventive solutions to complex situations of rights collusion and offer a proper balance between the contradicting individual interests in face of the Jewish and democratic elements of the state. Analysis of the Israeli judicial action throughout the years may prove the effort made by the courts in harmonizing between the Jewish and democratic character of the state. It searches systematically for the common humanistic values inherent in these two elements, which may reasonably balance between them. However, that cannot always be achieved. Part of the difficulties lie in the social political structure of the Israeli public, and part is due to hardship in breaking deep social and legal norms that have been rooted in Israeli life for many years. Changing them requires deep social reform in concept and in attitude, and can hardly take place successfully without it. In these complex situations, the court's contribution to the balance between freedom of and from religion is noted mainly in areas governed by administrative actions and by bylaws of local authorities, less so regarding primary legislation of the Knesset, which reflects majority rule based on political coalition agreements that render special weight to religious minorities who maintain political powers way beyond their size in the general community. However, the court contributes to the mitigation of this tension by using legal means of interpretation and creative decision-making aimed at bridging the gaps between conflicting values existing in this area. Israeli common law recognizes the existence of basic human rights to freedom of religion and freedom from religion, as I mentioned. These basic rights have been incorporated as part of the constitutional right to personal dignity embodied in our basic law regarding dignity and freedom of man. In the Israeli complex, multicultural social texture, and given the political coalition governmental structure, multicultural and religious clashes arise. The court endeavors at drawing the borderlines of legal protection rendered to freedoms of and from religion by creating a value system based on balance and proportionality. The starting point is that basic constitutional rights of freedom of and from religion are looked upon as rights that are not given absolute legal protection. In an organized multicultural society, one cannot achieve full protection of his basic constitutional right without getting into conflict with a contradicting basic right of another, calling for constitutional protection as well. Exercise of freedom of religion often involves conflict with freedom from religion, both being constitutional rights of the individual. The judicial solution to this conflict is found in the constitutional balance formula, which is embedded in our basic laws. This formula evaluates the relative weight of each conflicting basic right and searches for the point of balance between them. It sets the framework for defining the relative constitutional protection given to the various human rights in concrete situations. It is being applied in situations of two kinds. First, where conflicting individual rights are involved, and second, in case of conflict between a basic human right as freedom of religion as against contradicting important public interest of some sort. The Jewish character of the state plays a part in the balancing process as I described. Some typical examples descriptive of the clash between freedom of and from religion have to do with the observation of the Sabbath as part of the Jewish religious belief. In Israel, there has never been a question as to the right of an observant Jew to observe the Sabbath according to his belief as part of the freedom of religion bestowed upon him. But what about a secular individual who wishes to spend time on the Sabbath according to his own belief and lifestyle? To drive on the Sabbath, watch television, go to a restaurant or theater, and make use of public transportation. In one of the well-known constitutional cases, an administrative order to close down a main route in Jerusalem for car transportation on the Sabbath was judicially contested. The Supreme Court was called upon to reconcile the clash between two basic individual human rights: freedom of movement of the individual to drive within the city on the Sabbath, on the one hand, as against freedom of religion and religious feelings of the community living in vicinity to the route, on the other hand. The constitutional balance formula was utilized, the outcome of which was that the absolute prohibition on car transportation throughout the Sabbath day was struck down. But at the same time, the religious feelings of the community living in the neighborhood were given weight and consideration. The court directed the administrative authority to limit the closing order to prayer time only during the Sabbath day and permit transportation on the route throughout the remaining hours of the day. The decision was based on the rationale that religious feelings of the community or the individual do not justify full legal protection, but relative protection only. The total limitation of the contradicting basic constitutional right, in this case the right of movement on the Sabbath by the secular public, cannot be sustained. Only an act which would amount to a major offense on religious feelings, which goes beyond the reasonable tolerance which a person in a democratic society is expected to endure, may justify the full constitutional protection of freedom of religion in derogation of the conflicting right of movement. On the other hand, the secular public ought to respect up to a certain degree the religious practice of its neighbors and bear reasonable limitations on its rights of movement on the Sabbath. In the late 1960s, a question arose as to whether the Jewish character of the state may legitimize the imposition of a general prohibition on television programs on the Sabbath. The court dismissed a petition aiming to impose such prohibition based on the notion that offense to religious feelings may not justify administrative intervention in the private autonomous life of the individual within his home. An offense to religious feelings is unavoidable to a certain extent in a pluralistic society, and mutual concessions are required to mitigate conflicting beliefs and lifestyles in a free and democratic society. Up to the late 1980s, municipal bylaws prohibited theater and movie houses from operating on the Sabbath. Criminal indictment against an owner of a movie theater was struck down in court on the basis of lack of authority of the municipal body to pass a bylaw administrating the religious life of the community, lacking specific statutory authority in primary legislation to do so. It was also held that a reasonable constitutional balance between religious feelings of the Orthodox community and the autonomous rights of the secular individuals call for the opening of recreational facilities on the Sabbath for those who choose to spend their day of rest in such a manner. However, it was held that such rights of the secular community are to be exercised in reasonable distance from homogeneous religious communities, so as to prevent undue interference with religious practices and feelings. It is interesting to note in that context that the court affirmed the constitutionality of the statute prohibiting work of Jews on the Sabbath, stating that its basic dual goal is based on social and national values which coincide with the essence of Israel as a democratic and Jewish state. The general prohibition of work on the Sabbath is considered not only a religious directive, but mainly a historical, cultural, national feature of the Jewish state, uniting both religious and secular people under a common day of rest on the Sabbath. However, this should not derogate from the right of every individual to spend the Sabbath day according to his own belief and lifestyle. In that respect, the state has not offered as yet the full means to the non-religious community necessary to enable it to exercise its full autonomous rights, as, for example, operating public transportation and opening all recreational and cultural institutions of public interest on the Sabbath. Conflict between freedom of religion and contradicting secular mode of life arose with regard to the selling and consumption of pork meat in local communities. The limitations on selling of pork meat imposed by local authorities based on religious motives infringe upon the individual basic freedom of occupation of the merchant on the one hand, and on the personal autonomy of the secular individual wishing to consume food suited to his own taste on the other hand. The decision of the court, based upon the constitutional balance formula, ruled that legitimate limitations on the selling of pork meat should be based and conditioned upon the social character of the local community concerned, considering its residents' beliefs and lifestyle. Communities which are predominantly secular cannot be subjected to such limitations, being unconstitutional infringement on freedom from religion. Communities which are predominantly religious may prohibit the selling of pork within their municipal border. Allowing the selling of pork meat in such communities may offend the religious public's feelings beyond the reasonable endurance standard to be expected from a person living in a democratic, pluralistic society. A conflict arose regarding administrative prohibition based on religious grounds imposed upon women using public transportation from sitting in front seats on the bus reserved for men only. The court struck down this prohibition, declaring that any coercion imposed upon women, directing them where to sit on the public bus, is unconstitutional, being an infringement on the right of equality between man and woman. Respecting religious convictions within one's own community is one thing. while imposing coercive religious directives on others in the public domain is a totally different matter. Religious coercion shall not be allowed in public transportation, and tolerance will be the guiding line in such matters. Again, we view the clash between the two contradicting freedoms, which require balance and compromise, the theme being opposition to religious coercion in the public sphere, but at the same time, sensitivity to religious beliefs and feelings, and respect to the relative position in the social context. In the Israeli social reality, conflicts regarding freedom of belief are not limited to the interrelations between the religious and secular communities. There is a deep tension within the religious community itself, among its various branches and streams. A forceful controversy arose when a group of women of the Jewish Reform movement were prevented by the Orthodox authorities from praying according to their own special style at the Western Wall in Jerusalem. A conflict between worship rites of the Reform group as against the religious worship practices of the Orthodox community arose, building up strong emotions and tensions in the area. Again, the court applied the constitutional balance theory, deciding that the Reform group is to be allowed to pray in the Robinson Ark in vicinity to the Western Wall, but not at the wall itself. In so balancing, the court gave way to the right of worship of the petitioners on the one hand, respecting at the same time religious feelings and practices of the Orthodox community, praying regularly at the wall, relating also to considerations of public peace and security in the area. The end result of this judicial balance has remained in public controversy up to this day. Similarly, inner conflicts respecting conversion to Judaism processes have separated the religious community from within, involving at times deep infringements on human rights. The court was called upon to assist in solving these inner struggles within the religious community, which reflect directly upon human fate. As you can see, the main theme in balancing between conflicting basic human rights pertaining to freedom of and from religion is found in the point of equilibrium, by which individual freedoms may be relatively protected in a reasonable way within a pluralistic multicultural society. The modes of balancing and the legal outcome of this process remain at times in deep controversy, both within the court itself and in the public at large. Conflicts regarding freedom of religion are not limited to clashes with other contradicting individual rights. They arise in cases of conflict between freedom of religion and contradicting important public interests as well. Achieving important public interests essential to the social existence and its well-being may require certain limitations on individual freedoms. Freedom of religion and religious worship may conflict with basic national concerns of security and public order. Conflicts of that sort call for constitutional balance as well. These have brought about the use of the close likelihood legal doctrine, meaning that only close probability of occurrence of grave damage to the public interest may justify limitation on the basic human right of freedom of religion and worship. The claim of a religious group to worship on Temple Mount in East Jerusalem was denied for many years due to security and public order hazards. Limitations on freedom of religion are manifested in other areas of Israeli life where general public national interests are involved. As mentioned, The Israeli constitutional system recognizes the existence of basic human rights. At the same time, life in a democratic society demands the commitment of all its citizens to undertake civil obligations owed to the general public and the state, essential to its existence. Freedom of religion cannot justify the exemption of a large segment of Israel's Orthodox community from giving its share to the compulsory military service imposed upon every young citizen of the state. The constitutional value of equality, both as a basic human right of the individual and as a general public norm, does not permit inequality between religious and non-religious citizens pertaining to army compulsory service. Social and political processes in Israel have brought about a complex reality whereby many thousands of young Orthodox people decline to give their share in the military service, claiming that studying the Torah in the yeshivas is their main goal in life, and military service would stand in breach of their deep religious spiritual commitment. Based on constitutional principle of equality, the Supreme Court has decided years ago that army service obligation is imposed by constitutional norms equally on religious and non-religious communities. Exemption from service based on religious rationale is unconstitutional. However, deciding the matter on the constitutional ground has not brought the dilemma to an end. The problem as it stands today is not one of principle, but rather one of implementation. How to implement this legal constitutional obligation and bring it to realization, given the forceful opposition of the Orthodox community to abide by this legal directive, and considering the complex objective practical difficulties emanating from long years' segregation that have drawn Orthodox youngsters studying at the yeshivas far away from Israeli modern social reality. This issue exemplifies the difficulty in challenging complex, long-lasting social phenomena with legal tools, which are not always fully sufficient and efficient to bring about the necessary social change. At present, we are in the midst of a political effort to formulate a new law which would create an effective, gradual process of recruiting the young Orthodox to the army, following the striking down of the so-called Tal law, which was found ineffective to achieve that goal. Equality in the constitutional sense relevant to this issue does not necessarily mean that each and every individual must contribute to society precisely the same identical contribution. It means that there ought to be state mechanisms based on equality standards by which every individual is obligated to contribute to society according to his ability and capability. Respect for unique cultural and religious beliefs of a particular community is part of the democratic ethos, but this respect is not granted absolute legal protection in derogation of basic social obligations laid upon each individual essential to the existence of the social structure. Another general essential public interest which may require limitation on freedom of religion involves the social need for a connecting linkage between the various multicultural communities in the Israeli society. Without this connecting linkage, Israeli society may soon become a system of segregated congregations operating under broad freedoms protected by physical and cultural barriers, having no reference and no relation to one another. This need for a connecting linkage between the multicultural communities pertains both to the cultural spiritual sphere and to the physical aspect of the community's lives. A good example of the first kind is education. Respecting freedom of religion, an independent religious educational system has been widely developed in Israel, side by side to the state educational system. Some schools of the extreme Orthodox schooling system do not include in their curriculum general basic studies as history, geography, literature, sciences, and the like. Pupils of these Orthodox schools are not exposed to the general human intellectual creation and are unequipped in their adult lives to challenge realities of life in the Israeli society. Such pupils are gravely affected, and their rights to equal opportunities in life are severely harmed. Moreover, without creating a linkage between the various multicultural communities through basic education, social cultural harmony is hard to achieve. The court ruled that Orthodox schools are obligated to incorporate general course studies into their programs, denying those who do not abide by it the legitimacy to receive public funds. However, recent Knesset statute has been passed legitimizing financial public support to Orthodox schools, notwithstanding their decline to incorporate general course studies into their curriculum. The constitutionality of this law is now pending before the Supreme Court. The required connecting linkage between the segregated multicultural congregations is manifested also in the essential need to break through physical barriers that separate communities from one another in the residential neighborhoods. Physical seclusion of homogeneous communities, either religious or secular, has negative effects on efforts made to create a healthy, harmonious society. In recent years, the court dismissed a petition of a secular group opposing the construction of a religious public building in their neighborhood, claiming, among other things, that freedom from religion entitles them to maintain the secular atmosphere of their community, which a religious public structure would interfere with. This allegation was dismissed. The court decision emphasized that freedom of and from religion does not justify congregational physical segregation under the auspices of constitutional values. The necessary linkage between multicultural communities demands mutual concessions as expected in a pluralistic society ruled by democratic principles. Free movement and free interaction between religious and secular communal neighborhoods must be protected as long as law and order are respected. These are several examples reflecting on the process by which the Israeli constitutional system balances conflicting rights and public interests, drawing the fine borderlines of relative protection given to freedom of and from religion. The main theme underlying this process is directed towards reaching an inner balance whereby each individual and every community, whatever their belief and lifestyle may be, and every important public interest may find its relative recognition and relative place in the general life scheme of the society. This balance will rarely bring about absolute protection to any human right at the total expense of the other, or to full derogation of contradicting essential general public interest. According to the basic constitutional philosophy, every human right and every public interest should find its relative status in the general social scheme, so that balance will be achieved between rights and values as between the democratic feature of the state and its Jewish content. One cannot conclude this presentation without relating briefly to the grave constitutional difficulties posed by the laws concerning family matters in Israel. The law directing that marriage and divorce of Jews in Israel are governed by Jewish religion law was enacted soon after the establishment of the state, and a special rabbinical judicial system was instituted to adjudicate on these matters. The statute concerning marriage and divorce gives absolute value and weight to the Jewish religious element of the state, leaving no margin of consideration to freedom from religion and the right of free choice being part of the personal autonomy of the individual. As such, this law infringes upon the democratic nature of the state as protector of individual human rights. This law is immune from constitutional judicial review by a provision in our basic law. Coalition governments, including the religious parties, put barriers on the way to social reform, which is necessary to open up the system to a variety of processes of marriage and divorce suited to a multicultural communities of the Israeli society. This reality has caused grave difficulties to Jewish couples that for some reason the halakha prohibits their marriage. It affects mixed couples that cannot marry within the country in a legally valid marriage. It creates grave problems concerning conversion of non-Jews to Judaism. Various streams within Judaism itself struggle against the Orthodox monopoly in managing all religious matrimonial matters in the country. In this complex situation, people's personal fates are gravely affected, and as yet full remedy to cure these difficulties has not been offered. Throughout the years, the court has tried with its own tools to mitigate the harsh consequences on individual rights resulting from the imposition of religious law on marriage and divorce. It recognized the right of the Jewish or mixed couples who got married abroad in civil ceremony to register their marriage in the civil population register. Though this does not serve to validate the marriage according to Jewish law, it does enable couples to achieve some social recognition, accompanied by receipt of certain civil social rights. A court decision has also broadened the rights of non-Jewish residents in Israel to undergo a process of conversion to Judaism in a recognized Jewish congregation outside the country. Judicial decisions have weakened the Orthodox monopoly in supplying religious services to the public by striking down prohibitions on women and non-Orthodox individuals from participating in religious bodies of local communities. The Israeli constitutional system has not found as yet a balanced legal arrangement concerning marriage and divorce of Jews in Israel. The existing legal situation in this area has given unbalanced weight to the religious element of the state at the total expense of basic human rights of freedom of conscience and freedom from religion. This issue involves complex social and political reality, the change of which can hardly rely on legal and judicial tools only. There is need for deep reform in the basic social philosophy regarding rules of marriage and divorce in a multicultural society, a reform which would find its way to the legislature, which is the governmental body responsible for bringing about the change. A reform that shall balance correctly the needs of the religious community with the freedom of the secular public and recognize the non-religious individual's choice to materialize his matrimonial contact or bring it to dissolution by a non-religious process. So far, the social political structure in Israel has not come close to finding a common denominator needed for such change. One may conclude by saying that the constitutional democracy in Israel is marked by the duality of its Jewish and democratic nature, This duality is unique to the Israeli constitutional system and distinguishes it from other Western world regimes. In general, there is a constant effort to reach harmonious balance between the democratic and Jewish values underlying the state entity. However, this harmony has not been fully achieved as yet. In many walks of life, a reasonable balance has been achieved between freedom of and from religion by utilizing mechanisms within the legal balancing process. But there is still a long way to go, especially with regard to the basic fundamental right of the individual to personal autonomy in family life and in other areas, where proportionate balance has not yet been fully obtained. Full achievement requires a deep social change, both in philosophy and in action. The way to achieve the change is not easy. It requires the understanding that the Jewish character of the state does not depend on religious elements which are coercive and foreign to the non-religious community, being the majority of the Israeli society, but rather on the deep Jewish heritage based on its ancient history and its rich humanistic culture, on the Jewish philosophy and literature, the Jewish symbols and modern values of Zionism, all of which mark the unique features of our people. Religion is only one component in this multifaceted Jewish feature of our state and our people. It does not characterize it conclusively. The bridge between religion and constitutional norms is not easy to build since they speak different languages, both genuine and deep. One is a language of belief, and the other is a rational, humanistic language based on constitutional principles. But the search is for harmony between democratic element of the state and its Jewish entity, which is much broader than its religious component. Harmony may be achieved by revealing the common humanistic values hidden within these two philosophies. Those may link to one another to create a social system based on democratic roots, marked at the same time by the unique Jewish heritage ethos that has featured our people for many generations. Israel is the national homeland of the Jewish people. At the same time, it is a democratic country committed to the protection of human rights. The full harmonious combination of these two values lying at the core of our state has not been as yet fully achieved. Thank you very much, and Shana Tova.